Today we will discuss the doctrine of ultra-vires. Okay. Here we will discuss that what is doctrine of ultra-vires. The second thing, what is the importance of doctrine of ultra-vires. And the third thing is that with help of the different cases that has been provided in your case material, that how the law has been changing with respect to the doctrine of ultra-vires. Okay, because the main question in the doctrine of ultra-vires is the interpretation of the object clause, and business community is also very clever, so they have very ingeniously made the changes just to nullify the effect of the judgment. And then in the next case we will discuss the another thing. So similarly 5-6 cases are provided in your case material. Every case is important, and accordingly you will learn more thing about the doctrine of ultra-vires, how it has to be interpreted. And after discussion of all these cases you will get the holistic idea about the doctrine of ultra-vires. Okay. Now if someone asks to you, you came to Delhi for study, and if someone asks to you that will you do party tomorrow, and day after tomorrow you have the exam. Okay, the thing is very simple, that आज आपसे कोई पूछता है कि कल आप पार्टी करोगे और परसों का आपका एग्ज़ाम है और आप दिल्ली में पढ़ने के लिए आए हैं, तो आपका आंसर क्या होगा? यस, कोई बता सकता है? प्लीज. हाँ, what would be your answer? Yes or no?
No, sir.
No. But think about that why no. If that person also asks that why I'm sick, no, your answer will be कि I come to Delhi for study, that is my purpose. Okay. So in the daily life also we also focus, we also manage our conduct as per the purpose, as for the object we have taken for a particular task. कि भाई मैं तो पढ़ने आया हूँ, मैं पार्टी नहीं करूँगा, परसों का एग्ज़ाम है, और कुछ होता तो भी समझ में आता. सो ऑब्जेक्ट के अकॉर्डिंगली आप ये कर सकते हो. नाउ this thing is very important with respect to the company, because the poor company does not have body, does not have mind, and law में हमने कंपनी को बना दिया एक सेपरेट पर्सन. जो भी लाइबिलिटी होगी कंपनी की होगी, बिजनेस होगा वो कंपनी का होगा, प्रॉफिट कंपनी का, फाइनली उसको खाएंगे कौन? उसके शेयर होल्डर. लाइबिलिटी सारी कंपनी पे. एंड जस्ट टू सेव the company from any future liability, to limit the responsibility that would be taken by the company, object clause is used. तो object clause में we define that what company can do. Now anything that company is doing outside this object clause would be means without the power of the company, and that is known as ultra-vires. Ultra means beyond and vires means power. That means what a company can do if someone asks to you The company can do all those things that the Companies Act 2013 allows. Second, as that is within the domain of the object clause, or that is necessary for attainment of the object of the company. And the third one is the reasonably and fairly incidental to its object. Reasonably and fairly incidental, that mean अगर कोई एक बच्चा दिल्ली पढ़ने आता है परीक्षा के पर्पज़ से, सो वो किताबें भी खरीदेगा, रूम भी हायर करेगा, खाने का भी कहीं से टिफ़िन लगाएगा, वो कॉन्ट्रैक्ट भी बनाएगा. सो दीज आर द सब्सिडरी थिंग that are essential for the main purpose. So similarly here also company can do all those essential and incidental thing necessary for the attainment of the object. Okay. Now the act that is beyond the object or even cannot be considered as fairly incidental to attainment of the object would be considered as ultra-vires beyond the power of the company. And what would be the nature of that act? That act will not bind the company. The company will not be responsible for that act. You can compare this thing with your constitutional law classes so that you can better understand. In the constitution also, we have the Indian Constitution 1950, and by that constitution the federal structure is there कि सेंटर पे एक गवर्नमेंट होगी, स्टेट पे अलग अलग गवर्नमेंट होंगी, and those government has been assigned some power to do the act. The power that is given to those government, if they violate it, maybe it is with respect to fundamental rights, or maybe it is with respect to some other procedural thing, then that act would be considered as ultra-vires or unconstitutional. Okay, and so that would have no effect, void, shunya. Similarly here is that any activity done by the company that is not within its object clause, that is neither in its object clause nor can be considered as fairly incidental for attainment of the object, would be considered as ultra-vires, and in the law its effect is that these activity would be void, will have no effect of binding the company. Shunnya. Okay. Now the second thing, this is what is the object clause. The second is that what is the purpose of the doctrine of ultra-vires, or importance of the doctrine of ultra-vires. See, this thing I have discussed even when I have discussed the object clause also. Section 4 subsection 1 clause C talking about the object clause, that object has to be defined. The objects, so it may be one object, it may be two object, it may be three object, it may be four object, there is no limitation is there. But whether the object can be lawful or unlawful, section 4(1)(c) does not give the answer, but section 3 says that company can be formed for lawful purposes. That means object must be lawful at the time. So you cannot make a company for doing prostitution, you can do not make a company for supplying illegal arms, you cannot form a company for supplying rhino horns, etc. So all those things that are not legal that are not lawful, you cannot write into the object. But how you will write your object clause? The Company Act is silent on that. How many object you put it into it is also the company is silent on it. Company Act 2013 is silent. Okay. The purpose of the object clause or the purpose of the doctrine of ultra-vires is that if doctrine of ultra-vires would not be there, then company would also be responsible for those act that is beyond its object clause. Or you can say that the doctrine of ultra-vires save the company from all unauthorized act, and in this manner the doctrine of ultra-vires save the interest of the company as well as shareholders. Okay. Also, it protect the company from the directors, because directors are at the helm. They are at the key position and took all the decision on behalf of the company that is imputed by law on the company. And this doctrine of ultra-vires is also the limitation on the powers of the directors. Okay. The liability will be the persons who are doing that thing, because they must know that this is ultra-vires act. The company would not be liable. Now there is position, suppose there is the company X, and in that company X our Abhishek is director along with 2 other members, and then one of your class student have made the contract. He has supplied, he has even fulfilled his part of the contract. उसको supply करना था 2 ट्रक सीमेंट का, he has supplied. When he went for the money, उन्होंने कहा कि ये जो काम कर रहे हैं ये तो कंपनीज के ऑब्जेक्ट में लिखा ही नहीं हुआ, हमारा कंपनी तो जो है वो इलेक्ट्रॉनिक्स के लिए है. And now they have started business of the construction. Okay. So this is ultra-vires. Your money will not, we will not give the money, company will not give the money. You should know that what is the company's object clause. ऑफिस में लिखा हुआ था, रजिस्ट्रार ऑफिस में आपको चेक करना चाहिए था. And so somehow it is injustice to the third person. Okay. But it saved the interest of the shareholders and the company. But what is the remedy, what is the balancing, because law is for the balancing, and the third person, for the law the object clause is in the public domain, so there is a constructive notice also. This is the public document, and the very purpose of making it a public document is just to protect the interest of the outsider, that they should aware before contracting with a company. Even they should also know that whether the company will be what liability company will have, limited or unlimited, and that's why that thing also must be written in the name itself. Okay. So that's the justification for it. Now the consequence of the act that is beyond the object clause is that it would not bind the company. Who will be responsible? Who are actually doing, the director who did, who would be responsible. Now there is another thing. Suppose the company you have formed for the manufacturing of electronic item. Okay. And then the same example I am taking, that you ordered from your classmate 2 trucks cement, he supplied also, then he came for the payment. You said that our company is formed for the manufacturing of electronic item. but the cement was used for manufacturing of a particular soap or particular unit, and so that would be considered as an incidental to it. So it does not means that whatever words is written there, only that thing would be the power of the company. Any incidental thing would be power. Like suppose someone asks you that go to Calcutta, so that is purpose. But for going the Calcutta, you have to hire the bus or hire the train. So वो train making power भी आपके पास हो गई, because that is incidental to that. So incidental things has to be seen with the main object of the things. Okay, whatever the incidental power, whether the particular act would be incidental to the main clause or not, that we have to see in light of the object clause. Then the next thing is that, sir, suppose a company is formed and it is now not able to fulfill its object for which it is formed. So what would be its consequence? Because it cannot do the business तो कर ही नहीं सकती, and the consequence of that would be that it can be ordered for the winding up. In the German Date Coffee Company Limited, 1881-85, All England Reporter 372, that this case we will discuss on the winding up of the company, where the court said that when a company cannot carry out the object for which it was incorporated, so that means it lost its substratum and it has to be wound up. It has to be wound up, otherwise in the future it would create the confusion. It would be very unjust for the third parties, because they will contract for something for that the company will not be liable, and so it would create the confusion. So that is the consequence of a company who cannot carry out his business as per the object clause. Okay. Similar question may be, suppose you started a company for a particular thing. Now that would be illegal by the law passed by the parliament. Now you cannot carry on the business, and so again, the option is wound up. Okay. Here with this, what the company should do? The company should devote itself only to the object set out in the memorandum and no others, and so it is a function of the memorandum to delimit and identify the object in such a clear manner as the reader can identify the field of industry within which the corporate activities to be defined. A company may mention the various acts which are within the power of the company in addition to stating the object in the memorandum. But the corporate people, they always want to write more and more things in the object clause, so that if a particular activity cannot be obtained, they can shift over their business without making any change in the memorandum. Okay, and so they write as broad as much they could write in the memorandum, just to avoid this type of the hardship. But as I read that the company law clearly says that the object clause should be very clear. It is not necessary that it should always have only one object clause. It may be 2, 3, 4, 5, whatever it can say, but that must be clear so that it can be defined by the outsider. Outsider may know that to which particular object this company will be legally responsible or can legally do. Now the first case we will discuss here, that is very classical case, and the concept of doctrine of ultra-vires is not complete without the discussion of this case. The name of this case, as I have shared the screen here, is Ashbury Rail Carriage and Iron Company versus Riche. Ashbury Rail Carriage and Iron Company Limited versus Riche, 1874 to 80, All England Reporter 2219 HL. 1874 to 80, that does not mean that the case was decided or delivered for 4 years, etc. Basically this is for this reporter, All England Reporter. कम cases होते थे तो 5-6 साल की एक वॉल्यूम उन्होंने निकाली. So in that volume it was published. The citation is the place where you can find this case. So you have to find out the All England Reporter, this particular years and this volume. On that page you can find this judgment. Okay. Now see, the facts of this case are like, there is this company Ashbury Railway Carriage and Iron Company Limited, and this company was incorporated under the Companies Act 1862, and the object clause was, or the object for which this company was incorporated, is in the clause 3. Here you can find, I just highlighted. Any of you please read the object clause of the company, then I will read the activity done by the company. How you have to apply the doctrine of ultra-vires? Listen carefully, it is very simple. The doctrine of ultra-vires has to be applied to a particular act that is in the question. ठीक है, तो आपको बताना है कि ये जो काम कंपनी ने किया, क्या ये कंपनी के पावर के अंदर था या कंपनी के पावर के बाहर था. सारी लड़ाई ये है. तो आप कहोगे कि भाई मैं इसको किस चीज़ से कंपेयर करूं कि ये कंपनी के पावर के अंदर है या बाहर. सो फर्स्ट थिंग वन शुड नो or one should required for determining whether the act of a company is ultra-vires or not is the object clause. Okay, आपको object clause पता होना चाहिए. And the second thing is the alleged act. The alleged act means that act on which there is a dispute that it was beyond the power. And then you have to see that whether by any interpretation you can put this alleged act under any of the words used in this object clause. If you are able to prove, then it would be within the power of the object clause, it would be intra-vires, otherwise it would be ultra-vires. Okay. So here the object of the company Ashbury Railway Carriage and Iron Company Limited, who was incorporated under Companies Act, was, yes please any of you read this clause 3 of the memorandum. Clause 3 क्या होता है memorandum का? Object clause. Please read. पढ़ो भाई कोई.
The objects for which the companies established are to make or sell or lend on hire railway carriage and wagons and all kind of railway plants, fitting, machinery and rolling stock, to carry on the business of mechanical engineer and general contractors, to purchase, lease, work and sell mines, mineral, land and building, to purchase and sell as merchants timber, coal, metal or other material, and to buy and sell any such material on commission or as agents.
Yeah, thank you. So in the object clause there are 2-3 phrases. These 3 phrases we find. The first one is about to establish, make, sell, land or hire railway carriage and wagon and all kind of railway plant, fitting, machinery and rolling stock. The second is to carry on the business of mechanical engineers and general contractor. Okay, so basically the company was, if you see the name also, where we can get the idea of Carriage and Iron Company. So this company was a company that has to prepare, मैन्युफैक्चर द कैरेज एंड द वैगन. रेलवे की जो बोगीज़ बनती है ना, सो अब रेलवे की बोगी बनेंगी तो उसमें आपको उसको बेचने का भी अधिकार होना चाहिए, उसमें लोहा भी खरीदोगे, उसके लिए कॉन्ट्रैक्ट भी आप बनाओगे. रेलवे की बोगी ऐसा तो नहीं एक अकेला आदमी बना दोगे, किसी के साथ मैकेनिकल कॉन्ट्रैक्ट करोगे, इंजीनियर्स हायर करोगे. सो ऑल दीज पावर्स यू विल फाइंड इट. And the business community or the person who formed this company was aware that for doing the business of manufacturing of the railway wagon, they need certain things, like they have power to sell, they have power to hire, they have power to even make the contract with mechanical engineers, और कोई और भी तरह के कॉन्ट्रैक्ट हमें बनाने पड़ेंगे, और आयरन और हमें लेना पड़ेगा, लकड़ी हमें लेनी पड़ेगी. So all these things taking into the consideration, the object clause was formed, that is in three parts. The first part is for making, selling, land or hire of railway carriage and wagon and all kind of railway plant, fitting, machinery, rolling back, जो उसमें fit होते हैं ना वो सारी चीज़ें. Second, to carry on the business of mechanical engineer and general contract. Third is to purchase, lease, work, sell, mines, mineral, land and building. And then fourth one is to purchase and sell merchant, timber, coal, metal or other material, and to buy and sell such material on the commission or as a agent. So these four objects are there. Now what this company did, that there was a very influential person, Mr. Riche. Okay, and he got a license for laying the railway line, and this company entered into the contract with Mr. Riche, a firm of railway contractor. Mr. Riche, who was the partner of that firm that having the railway contracts, and this firm in which Mr. Riche is one of the member has got the contract of laying down the railway line from point A to B, and he need money. Okay, so the railway line that has to be constructed in the Belgium, and Mr. Riche has got that contract. He need the money, so he contracted or he approached to the Ashbury Railway Carriage and Iron Company Limited and asked for money for financing my project. And this poor company has contracted to finance the construction of the railway line in the Belgium. So the act is that contract of financing for a construction of railway line. So this was the act, and this act was challenged that it is ultra-virus, it is beyond the powers of the company. Okay, now arguments from the both the side. Okay, argument from the company side or from the in favor of that this is intra-virus, that see there is a term after mechanical engineers and general contractor. So the argument was that the power given in the second, you can say, object, where the company can also do the work of general contract, and general contract mean any type of the contract, and so the company's act is within its power. The arguments from the company side is that it is beyond its power, it is ultra-vires, because the general contract word here or the different phrases here are written has not to be read in independently, but has to be seen with the main objective. And the main objective, if you see, is for the construction of the railway wagon, selling, etc. And so general contractor also has its limited meaning, only limited with the contract making power of the company with the main object. And that means any contract with somehow related with the these objects mentioned in the object clause. But the contract of financing a particular firm for construction of the railway line is in no way is incidental for fulfilling the main clause. Okay, so both sides have argued well. Now the question is before you, ऑब्जेक्ट क्लोज इज़ बिफोर यू, ब्लू लाइन्स में लिखा हुआ है. एक वर्ड भी मैंने बता दिया जनरल कॉन्ट्रैक्ट में लाने की कोशिश हुई, बाकी तो सब स्पेसिफिक वर्ड है, उसमें आएगा नहीं. ओके, एक्टिविटी बता दिया. द एक्ट दैट इज इन द क्वेश्चन इज दैट द रेलवे कैरेज एंड आयरन कंपनी मेड ए कॉन्ट्रैक्ट टू फिनेंस द मिस्टर रिच फर्म for construction of the railway line in Belgium. Okay, yes, now you decide, please give the answer. बोलिए भाई, it's not so hard. Yes, Mr. Abhishek, would you like to answer? Manjeet, Ravinder, any of you would like to answer this thing? क्या होगा? कंपनी ने जो जनरल कॉन्ट्रैक्ट किया फॉर फाइनेंसिंग द कंस्ट्रक्शन ऑफ रेलवे लाइन, क्या ये अल्ट्रा वायरस है या कंपनी के पावर्स के अंदर है? इंट्रा वायरस. ओके, हाउ?
रेलवे की कंस्ट्रक्शन के लिए हुआ है, मतलब उन्होंने किसी और के लिए सर मतलब नहीं किया कि रोड बनाने के लिए या कुछ और बनाने के लिए, रेलवे के लिए उन्होंने फाइनेंस किया है इसको.
बट उस रेलवे में उनकी गाड़ियां थोड़ी जा रही हैं, उनके वैगन थोड़ी यूज होंगे, उनके वैगन से रिलेटेड थोड़ी चीज़ें होंगी, वो तो केवल फाइनेंस कर रहे हैं. अगर वो कॉन्ट्रैक्ट होता कि उनके वैगन जाएंगे या उनके वैगन से कुछ होगा या उनके वैगन बनाने में कोई सामग्री से रिलेटेड कॉन्ट्रैक्ट होता, तब तो समझ में आता. केवल रेलवे नाम है तो इसका मतलब थोड़ी है कि वो इंट्रावायरस हो.
आखिरी लाइन ये भी तो लिखी, बाय एंड सेल एनी सच मटेरियल्स ऑन. अच्छा, मटेरियल्स
तो मटेरियल कहाँ बेच रहे हो, तो पैसे दे रहे हैं. ओनली फाइनेंसिंग इज दे आर डूइंग. ब्याज पे रुपया चढ़ा रहे हो तो, और कुछ नहीं है.
मनी भी एक तरीके से मटेरियलिस्टिक सपोर्ट है सर.
नो नो नो, ऐसा नहीं. मनी मेटेरियलिस्टिक सपोर्ट है, बट मनी मटेरियल तो नहीं ना. सेलिंग मटेरियल इज़ डिफरेंट थिंग यार. मनी को सेलिंग मटेरियल आप कैसे कह दो? चलो मटेरियल भी आपने बोल दिया, बड़ा ही फिलोसफिकल कि सब मोह माया है सब, बट सेल तो नहीं होगा ना. मनी कैन नॉट बी सेल्ड आउट. पैसे को सेल कर सकते हैं हम? कन्वर्जन तो होता है, सेलिंग तो नहीं होता। मैंने किसी को पता है, कोई बोलना चाहेगा? मंजीत, सोनाली, सोनाली आपको क्या लगता है, व्हाट वुड बी आंसर अकॉर्डिंग टू यू?
सर वो मेरा नेटवर्क चला गया था अभी तो।
नो इश्यू। See, one example I want to give. See, the main issue is that whether this general contractor, the company can work as a general contractor, whether this word has the capacity to include this type of the contract, that means contract of any nature, or should we read this word also in the limited sense? There is the principle that you will read under interpretation of the statute also, ejusdem generis, ejusdem generis, ejusdem generis. That means if there are the different words, though the principle is slightly different, there is some requirement that there are some specific words, and after specific words, if there is a general word and these specific word make a class, then this general word also take the color of these specific words. Suppose you are organizing a party, आपने पूछा किस किस को बुलाएं, एंड अभिषेक को बताया कि आप भाई उसको बुला लो, परमिंदर को बुला लो, मंजीत को बुला लो, नवीन को बुला लो, 3-4 लोग जो आपके क्लास में हैं, और ठीक है, एंड फिर लास्ट में कहा उस नवीन को बुला लो, मंजीत को बुला लो, परमिंदर को, और किसी को भी देख लेना। नाउ यहाँ पे जो जनरल वर्ड यूज़ किया है, और किसी को भी देख लेना। नाउ अब यहाँ पे बंदा अपना ही कोई कजन बुला के ले आया, और जब क्वेश्चन हुआ कि आप अपना कजन क्यों बुला के लाए, सो ही आंसर्ड दैट यू सेड दैट एनीवन कैन आल्सो बी. So here the anyone has to be seen in light of those specific word. Manjeet, Parminder, Ravinder, they are from this class. So this any word means any other person from this class. Okay. So similar thing is similar we can take that this general contract also be, we have to see in light of the main purpose of the company. If the general contract will take in its independent an object, then it would have the capacity to include each and everything that is possible to act through the contract on this earth, and so that would not be the proper interpretation. And so this judgment that you have in your case material, it judgment is from 3 judges. You have to read only the judgment written by Lord Chancellor Carriage. That is more than sufficient. You have to leave this Lord Hatherley and Lord Selborne judgment. But if you want to read, then you can read the judgment from these 3 judges. Here, I just shared the screen here. And from this judgment of Lord Chancellor Carriage, first taken from the 3rd para. The 3rd para is very important, and this 3rd para will give you the whole answer. Would any of you like to read this 3rd para? The action was brought by the plaintiff. Yes, read it.
By the plaintiffs, who are the contractors in Belgium, to recover damages for the breach of an agreement entered into between the plaintiff and the appellants. The Ashbury Railway Carriage and the Iron Company Limited. This company was established under the Joint Stock Companies Act of 1862, and I think it will be therefore necessary to consider with some minuteness some of the leading provisions of that Act of Parliament. But in In the first place, it may be convenient to ascertain the purposes for which this company was formed and also the nature of the contract for breach of which the action was brought. The purposes for which a company established under the Act of 1862 is formed are always to be looked for in the Memorandum of Association of the company. The Memorandum of Association of this Ashbury Railway Carriage and Iron Company Limited declares that it was formed for these objects. Part of the argument at your lordship's bar was as to the meaning of two of the words used in this part of the agreement, the word general contractors. As it appears to me, upon all ordinary principles of construction, those words must be referred to the part of the sentence which immediately precedes them. The sentence which I have read is divided into four classes of words. First, the selling or lending railway carriages, wagons, and all kinds of railway plant, fittings, machinery, and rolling stock. This is an object sui generis and complete in the specification which I have read. Secondly, to carry on the business of mechanical engineers and general contractors. That again is the specification of an object complete in itself, and according to the principles of construction, the term general contractors would be referred to that which goes immediately before and would indicate that the making indicate that
The
contractors
hmm.
would be
Yes, yes.
referred to that which goes immediately before and would indicate the making generally of contracts connected with the business of mechanical engineers. Such contracts as mechanical engineers are in the habit of making and are in the business required or to find it convenient to make for the purpose of carrying on their business. The third is to make purchase, lease, work, and sell mines, minerals, land, and buildings. That is an object pointing to the working and acquiring of mineral property, and the generality of the last two words, lands and buildings, is limited by the purpose for which lands and buildings are to be acquired, leasing, working, and selling of mines and minerals. The fourth head is purchasing and selling timber, coal, or metals or other materials, buying and selling any such materials on commission as agents. That requires no commentary. If the general contractors is to be interpreted as I have stated, the consequence would be this, that it would stand absolutely without any limit of any kind. It would authorize the making, therefore, of contracts of any and every description, and the memorandum in place of specifying the particular kind of business would virtually point to the carrying on of business and any kind whatsoever, and would therefore be altogether unmeaning.
Yeah, thank you, Abhishek. So, the Lordship has observing that in the interpretation of the object clause, we have to follow this rule that every word will not be taking its independent meaning. Rather, we have to follow the main object rule. And according to the main object rule, the different objects that are framed in a object clause, like here 4 objects has been defined. And with respect to the main object, like in the first object this is, so जो general word उसके साथ use होंगे, that has to be seen in light of the main object. So this case has established the main object rule, and the specific issue fall here is the general contractor. So what will be the true meaning of the general contractor? When we see the object clause of the company, it is divided in 4 objects, and the second object that we are concerned is saying that to carry on the business of mechanical engineer and general contractor, and so the general contractor will take the meaning of the anything that is with the mechanical engineer that is required. Okay, and general contractor does not means anything or any possible thing independent of the mechanical engineer. If this interpretation we would give, that the general contractor means does not be limited in light of the its preceding word, then it would altogether be unmeaning, because it would have the capacity to include each and every type of the activity that a company can do through the making of the contract. Okay, कुछ भी काम फिर तो वो कर सकती है. एंड सो द वेरी पर्पज ऑफ द ऑब्जेक्ट क्लॉज इज फ्लोड, द वेरी पर्पज एज वी डिस्कस टू प्रोटेक्ट द कंपनीज इंटरेस्ट. एंड सो हियर the general contractor word has to be seen with the main object rule, and the main is it is falling under the second object, that is with respect to making the mechanical engineer. So any contract that is applicable in the mechanical engineering, in that aspect that would contract would be proper if the company in this particular case also if had contracted for supplying the mechanical assistance for the railway line, then it would be, but it has not did that, rather it has contracted for the finance, so that would in no way be included into the object clause. The word general contract has to be seen with respect to the main object rule. And so this case has held that the different words may be used, like in the third clause also Lord Carriage is observing that the word land and building is used. So it does not mean to every land they can do. So for that, land and building also has to be seen with the object thing. So different words that is used in the object clause, or if there are more than one object, like here char object thing, if there are more objects, and in those objects you will find some general words also. So those general word will not in itself became a the object clause, in itself became a particular specific object, but they have to interpret it, they have take the meaning, they have to be seen in light of that particular object. Okay, so this is the decision of this case, and with this case today class is over, because we have exhausted all the time.